Hello and welcome to In Depth. My name is Aditi Lokpal. Almost a year after the country's first Lokpal was appointed, the Ministry of Personnel, Public Grievances and Pensions has notified the Lokpal rules. A notable feature pertains to complaints against a sitting or former Prime Minister, which the rules state that a full bench will decide if an inquiry should be ordered. Also, under the rules, if a bench decides to dismiss the complaint at the stage of the admission, the records will not be made public. The Lokpal and Lokayuktas Act 2013, commonly known as the Lokpal Act, is an anti-corruption act of Indian Parliament in India. It sets up the institution of Lokpal to inquire into allegations of corruption against certain important public functionaries. They would also include the Prime Minister, Cabinet Ministers, Members of Parliament, Group A officials of the central government. Today in Depth, we'll talk about the Lokpal Complaint Rules 2020. In particular, about what they say about complaints filed against the Prime Minister. We'll also look at the institution of the Lokpal, the powers it has been granted, and its essential functions. Earlier this week, the government notified rules for filing of complaints before the Lokpal. The rules enable the anti-corruption ombudsman to act on the pleas made before it, specifying norms on how to deal with allegations made against a public servant, including the Prime Minister, Members of Parliament and bureaucrats, among others. Let's first look into what the rules state with regard to complaints to be filed before the Lokpal.
"11 months after the formation of the Anti-Corruption Ombudsman Lokpal, the government has issued a format for filing complaints of alleged corruption against public servants, including the Prime Minister. The notification was issued on the 2nd of March 2020 by the Ministry of Personnel, Public Grievances and Pensions. The Lokpal Complaint Rules 2020 specify that a complaint can be filed with the Lokpal against the Prime Minister, a Minister of the Union, Rajya Sabha and Lok Sabha members and bureaucrats, among others. A complaint filed against the Prime Minister shall be decided by the full bench, comprising its chairman and all members in the first instance at the admission stage. If such a complaint is dismissed by the full bench of Lokpal, records of the inquiry shall not be published or made available to anyone. On a complaint filed against a union minister or a member of parliament, the rules state that it has to be decided at the admission stage by a bench consisting of not less than 3 members of the Lokpal. The rules bar any complaint filed against a public servant under the Army Act, Navy Act, Air Force Act or the Coast Guard Act.
The full bench of Lokpal consists of the chairman and 8 members. There cannot be more than 8 members, to be selected by the committee of the Prime Minister, headed by the Prime Minister, and there has to be 50% judicial members and the remaining 50% have to be from SC, STs, OBCs, minorities, women's, and it is a completely independent body.
The Lokpal Complaint Rules 2020 also state that all complainants have to mandatorily give an affidavit on non-judicial stamp paper that making any false and frivolous complaint is punishable with imprisonment of jail term, which may extend to 1 year. It will also attract a fine of up to 1 lakh rupees. The complaint may ordinarily be made in English in the manner as laid down by the Lokpal, by post or in person. However, when the complaint is filed electronically, a hard copy shall be required to be submitted to Lokpal within a period of 15 days from the date of filing. As per the rules, Lokpal shall not keep the said complaint received electronically as pending if it is complete in all respects. Lokpal can also entertain a complaint in any of the 22 languages, including Hindi, Gujarati, Assamese and Marathi, referred to in the 8th schedule to the Constitution. A complaint shall contain the details of allegations about commission of an offence by the public servant, which include the Prime Minister. Besides a duly signed detailed statement making out the allegation, the complaint should also have a copy of the identity proof in a specified format and registration or incorporation certificate of the organization on whose behalf the complaint is being made. The Lokpal shall dispose of a complaint within 30 days. Further, the Anti-Corruption Ombudsman has to protect the identity of the complainant or the public servant complained against till the conclusion of the inquiry or investigation. The rules also spell out the grounds on which the Lokpal can dispose of a complaint. If the contents of the complaint are illegible, vague or ambiguous, trivial or frivolous, where the complaint does not contain allegation against a public servant, or where the cause of the complaint is pending before any other court or tribunal or authority, and the alleged offence in respect of which the complaint is being made is within the period of 7 years. A non-citizen of India can also file a complaint. Only a copy of the passport will be accepted as proof of identity.
There is a format of a complaint which has been given. Now this has to be for corruption under the Prevention of Corruption Act of 1988, and it covers the Prime Minister, ministers, MPs and Group ABCD members of the government service, and therefore there is for this purpose there is an inquiry wing and prosecution wing in the Lokpal, and there is a preliminary inquiry. After the preliminary inquiry, there has to be a finding whether the complaint has to be dismissed or admitted. After the admission, it is can be given for probing to any agency like CBI, and thereafter the prosecution will start.
According to the rules, there is a provision for a chairperson and a maximum of 8 members in the Lokpal panel. Of these, 4 need to be judicial members. With the format now notified, the Lokpal can send complaints to the inquiry wing of the Lokpal, which may then order a preliminary inquiry. And if there is a prima facie case, the Lokpal can refer the complaint for an investigation by a probe agency like the CBI. According to the latest available data, a total of 1,065 complaints were received till September 30, 2019, out of which the Lokpal disposed of 1,000 complaints. Bureau Report, Rajya Sabha TV.
A Lokpal is an anti-corruption authority who represents the public interest in India. The Lokpal has jurisdiction over the central government to inquire into allegations of corruption against its public functionaries and for matters connected to corruption. In this report, let's take you through the powers and duties of a Lokpal.
I, Pinaki Chandra Ghosh, having been appointed Chairperson Lokpal,
on 19th March 2019, Justice Pinaki Chandra Ghosh was appointed India's first Lokpal.
that I will bear true faith and allegiance to the Constitution of India.
The announcement came after the Lokpal and Lokayuktas Act was passed after a delay of 5 years. The Act envisaged the appointment of a Lokpal at the centre and Lokayuktas in the state to look into complaints against certain categories of public servants that are defined under the Lokpal Act 2013. The Lokpal falls in the category of institutions that are statutory bodies without any constitutional status. This body is constituted to check the menace of corruption in India under the Lokpal and Lokayuktas Act 2013. The Act extends to the whole of India and shall apply to public servants in India and abroad. The Lokpal is a multi-member body that consists of a chairperson and a maximum of 8 members, of whom 50% are judicial members. 50% members of Lokpal have to be from SC, ST, OBCs, minorities and women. The term of office for Lokpal chairman and members is 5 years or till attaining age of 70 years. The members who select the Lokpal are to be appointed by the President on the recommendations of a selection committee. The selection committee is made up of Prime Minister, Chairperson, Speaker of Lok Sabha, Leader of Opposition in Lok Sabha, Chief Justice of India, or a judge nominated by him or her and an eminent jurist. The jurisdiction of Lokpal includes Prime Minister, ministers, members of parliament, groups A, B, C and D officers and officials of central government. The Lokpal also covers chairpersons, members, officers and directors of any board, corporation, society, trust or autonomous body either established by an act of parliament or wholly or partly funded by the centre. It covers any society or trust or body that receives foreign contribution above 10 lakh rupees per year. The Lokpal, however, cannot inquire into any corruption charge against the Prime Minister if the allegations are related to international relations, external and internal security, public order, atomic energy and space. The Lokpal does not have jurisdiction over ministers and MPs in the matter of anything said in Parliament or a vote given there. It has the powers to superintendence over and to give direction to CBI. The inquiry wing of the Lokpal has been vested with the powers of a civil court. Lokpal has powers of confiscation of assets, proceeds, receipts and benefits procured by means of corruption in special circumstances. It has the power to recommend transfer or suspension of public servant connected with allegation of corruption. Lokpal has the power to give directions to prevent the destruction of records during the preliminary inquiry. If the Lokpal receives a complaint under the Prevention of Corruption Act 1988, then it can initiate the investigation.
Now this complaint, Lokpal can dismiss at the first stage if it is vague, frivolous, does not disclose any complaint or allegations against a public servant, or the matter is pending before any other court or tribunal. This complaint has to be filed within 7 years of the offence being committed. It cannot be filed. There can be no complaint against public servant under the Navy Act, Army Act or the Air Force Act. Further, if the subject matter deals with the international relations, internal and external security, atomic energy and space, there can be no complaint with relation to these subjects.
The institution of Lokpal has tried to bring a much-needed change in the battle against corruption in the administrative structure of India, but at the same time, there are loopholes and lacuna which need to be corrected. Bureau Report, Rajya Sabha TV.
With this, we'll halt in for a quick breather, but we'll be back soon. Stay tuned with us.
Finance Minister recently launched Ease 3.0 to improve customer relations and also to enhance ease of banking.
It was Ease 1, then Ease 2 and now Ease 3, where more emphasis has come on the technology part because a lot of developments have taken place, and to ensure that it is very transparent. Evaluation is by an outside consultant.
You see a turnaround in the banking sector because of improvement in the asset quality due to enhanced resolutions because of insolvency and bankruptcy court?
Where there are complications, we would definitely prefer IBC route for resolution.
Sir, the RBI governor also says that prudent lending does not mean that you stifle lending. How is SBI maintaining that balance?
His approach has been also to take care that we meet the needs of these, recognize there is stress in certain sectors.
Watch To The Point with Rajneesh Kumar, Chairman, State Bank of India. Only on Rajya Sabha TV.
Welcome back. You're still with us on In Depth. The Lokpal and Lokayuktas Act 2013 has had a long and checkered history. It took almost 45 years to enact this important piece of legislation. And it is perhaps the only legislation in the history of the country which has been so widely discussed both inside and outside Parliament, and has thus created much awareness in the public minds.
The institution of Lokpal was first thought of in the early 1960s with the aim to root out corruption in public offices. The bill was introduced for the first time in Lok Sabha as the Lokpal and Lokayuktas Bill 1968. Since then, the bill has been introduced 9 times in 1971, 1977, 1985, 1989, 1996, 1998, 2001 and twice in 2011. The new Lokpal Bill introduced in August 2011 was referred to the Department-related Parliamentary Standing Committee for examination. On the basis of the recommendations of the committee, the Lokpal Bill 2011 was withdrawn, and the revised Lokpal and Lokayuktas Bill 2011 was reintroduced in Lok Sabha in December 2011. The bill was passed by Lok Sabha with certain amendments, but the discussion on the bill in Rajya Sabha remained inconclusive. It was then referred to the Select Committee for further analysis. The bill was amended as per the recommendations by the Select Committee, and the amended bill was taken up for consideration in the Rajya Sabha in December 2013. The bill was passed by Rajya Sabha with amendments and was then taken up for consideration by Lok Sabha. The Lokpal and Lokayuktas Bill was passed by both houses and received the President's assent in January 2014. The Lokpal and Lokayuktas Act 2013 provides for the establishment of a body of Lokpal for the Union and Lokayukta for states. Lokpal and Lokayuktas are to inquire into allegations of corruption against certain public functionaries and matters connected with them. The Lokpal's jurisdiction covers all categories of public servants. The Act provides that an inquiry against the Prime Minister has to be held in camera and approved by a 2/3 majority of the full bench of the Lokpal. The Prime Minister cannot be investigated if the complaint is related to international relations, external and internal security, public order, atomic energy and space. The Lokayuktas have jurisdiction over the Chief Minister, ministers, MLAs, all state government employees and certain private entities, including religious institutions. The Lokpal's inquiry wing is required to inquire into complaints within 60 days of their reference. On considering an inquiry report, the Lokpal shall order an investigation, initiate departmental proceedings, or close the case and proceed against the complainant for making a false and frivolous complaint. The investigation has to be completed within 6 months. The Lokpal may initiate prosecution through its prosecution wing before the special court set up to adjudicate cases, and the trial has to be completed within a maximum of 2 years. The Act also removes the requirement of sanction for initiating investigation and prosecution and penalizes false and frivolous complaints with imprisonment for a maximum of 1 year and a fine of up to 1 lakh rupees. The Lokpal also has the power of superintendence and direction over any central investigation agency, including the CBI, for cases referred to them by the Ombudsman. And it can attach and confiscate property acquired by corrupt means, even while prosecution is pending. The Act also lays down clear timelines for preliminary inquiry and investigation and trial. Bureau Report, Rajya Sabha TV.
In the beginning of the 1960s, the necessity of the institution of the Ombudsman was felt in India on the lines of those in Scandinavian countries. Hence, after several attempts by successive governments, anti-corruption units at both the centre and the states were formed as Lokpal and Lokayuktas. Our next report looks at the more than 43-year journey of the formation of the Lokpal.
The word Lokpal etymologically means protector of the people. The term is an Indian variant of ombudsman that refers to an official who investigates complaints of citizens against the administration. The genesis of the concept in India dates back to the 1960s. On 3rd April 1963, late Dr. L.M. Singhvi, while participating in a parliamentary discussion in the Lok Sabha, stressed the need to set up a parliamentary commission on the pattern of ombudsmen to tackle corruption. Singhvi also coined the terms Lokpal and Lokayukta. In 1966, the first Administrative Reforms Commission recommended a 2-tier machinery to redress the grievances of the public, that is the Lokpal and Lokayukta. The Lokpal would deal with complaints against ministers and secretaries of the central government as well as in the states. The Lokayukta, one for the centre and one in each state, would attend to complaints against the rest of the bureaucracy. Apart from the first ARC and the parliamentary committees, the second ARC and the National Commission to Review the Working of the Constitution 2002 have recommended various aspects of the institution of Lokpal.
Prime Minister is the highest office in the executive, although the formal head is the President, and therefore there has to be a special procedure out there so that the full bench decides about the admissibility of a complaint about the Prime Minister. Once it is decided there is no substance in the complaint or there is no prima facie material, they will dismiss it, and that material will not be disclosed or published to anyone.
There have been many significant movements urging the government to act against corruption. A new era of change began in 2011 when Anna Hazare, an anti-corruption crusader, went on a fast unto death on April 5th, demanding that Jan Lokpal bill drafted by the civil society should be adopted. 4 days into his fast, the government agreed to set up a joint committee with an equal number of members from the government and the civil society to draft the Lokpal bill together. Both sides met several times but could not agree on fundamental elements like including the Prime Minister under the purview of the Lokpal. Eventually, both sides drafted their own version of the bill. The Lok Sabha debated the Lokpal bill on 27th December 2011. The debate resulted in the bill being passed and sent to the Rajya Sabha, but the new 9-member Lokpal panel was not given constitutional status because the government failed to get the necessary 2/3 majority of MPs present. The Lokpal bill was then sent for review to the then President Pratibha Patil on 28th December 2011. She later gave her assent for the bill to be tabled in the Rajya Sabha. The government reintroduced the bill in the Rajya Sabha in February 2012. And the session ended without this bill being passed. Parliament, however, enacted the Lokpal and Lokayuktas Act 2013.
See, nobody is above the law in a parliamentary democracy. The highest office of the Prime Minister is also subject to Lokpal because also in the past there have been allegations against the Prime Minister of corruption. So therefore, I think it is a very good thing that everybody comes under the, even the highest office of the Prime Minister comes under the Lokpal Act.
In order to file a complaint under the Lokpal Act, citizens were advised to file complaints only regarding corruption and not other complaints related to pensions, service-related issues, etc. Although the form for filing complaints has been notified on March 2, 2020, the Lokpal has decided to scrutinize all the complaints received in its office in whatever form they were sent till then. 1,065 complaints were received till 30th September 2019. 1,000 have been heard and disposed of. After scrutiny, complaints that did not fall within the mandate of the Lokpal were disposed of and complainants were informed accordingly. Since the Lokpal is an apex body that deals with cases of corruption at the national level, it has to inquire into allegations of corruption against public functionaries of the central government in a time-bound manner. With inputs from Vipul Agarwal, Bureau Report, Rajya Sabha TV.
So with this, it's a wrap on this edition of In Depth. Thank you so much for watching.